Okay, is that all right?
That works for me. It helps me
Fine.
follow what you're saying better.
Okay, great. Thank you so much for letting us know. Okay, so we're gonna just move on to, we covered acronyms and abbreviations. We covered meeting notices. We're just gonna cover this briefly. So matters not reasonably anticipated by the chair must be added to the agenda after the posting deadline to the extent feasible. And an updated agenda must show the date and time as well as the change to the agenda. Matters that are not reasonably anticipated by the chair may be discussed. However, the Attorney General's Division of Open Government recommends that unless a matter requires immediate action, it should basically be put off to a later meeting and included in the posted 48 hours in advance, business hours in advance of the meeting. I will say I've handled these matters in the past about what is or is not reasonably anticipated. And essentially, it is a very fact-specific analysis. What really is in the chair's mind? Was it anticipated at the time? So certainly something to be aware of. If you think that something's not reasonably anticipated, to talk about that analysis. So posting notice, some practical points or practice pointers. We want to always timestamp the notice to ensure accurate record exists of the filing. A meeting cannot be continued from one night to the next night unless the meeting is properly posted under the open meeting law and for the continued time. So I always say, if you think, particularly at a busy time of year, you might have multiple meetings on a particular topic, there's never a harm to post all of those meetings at the same time. So what was that? The notice required under the open meeting law does not substitute or supersede other notice or requirements under other applicable laws. And I would in particular note 40A as an example of that. So you always want to make sure you're not only complying with open meeting law requirements, but you're also complying with other statutory requirements for notice. Emergencies. This is one of the topics when there's bad weather in the winter, bad weather, hopefully not this summer, but bad weather in the summer. I always get the question, well, what constitutes an emergency? And I always start with the premise that poor planning does not equal an emergency for open meeting law purposes. I know that town officials, town personnel are always dealing with emergencies. But for open meeting law purposes, it essentially is limited to public health emergencies, natural disasters, and significant public safety issues that would really be an emergency matter. Before COVID-19, majority of emergencies were generally limited to weather-related issues, blizzards, hurricane, ice storms. There are, of course, other examples of that, but certainly something to be aware of that the burden is fairly high for what constitutes an emergency. Some practical recommendations, if you do have an emergency, and I'm hoping that no one has an emergency, we want to comply with the law to the extent possible. You want to limit the public body's deliberations to just that emergency matter. You're going to want to take minutes of that meeting, just as you would for any other meeting, and review and include them with the minutes of the next regularly scheduled meeting. If you are posting an emergency meeting, consider posting a regular meeting as well, to essentially allow the public body to ratify that action taken. Conducting meetings, recordings. If you are going to record your meeting, just as we're recording tonight, and we made that announcement for anyone that's participating remotely, and we made it for the people here in person, the chair must make a public statement regarding audio or video recording if attendee intends to record. And that is required under the Massachusetts wiretap statute. If an individual wants to record, I used to say when I started doing these trainings many years ago, we all had tripods and large, camcorders. The technology obviously has become smaller. Most of the time, if people record, it's with their phones. But the individual does have to inform the chair. I would like to make a recording of this, and the chair has to make the required announcement. So basically, if someone in the room doesn't want to be recorded, they're on notice of that. The chair can reasonably regulate where the recording is. We don't want to block someone else's view. Like I said, where technology has gotten smaller, it's certainly something to be aware of. The current state of the open meeting law, so we know the remote meetings are still allowed until under state law, until March 31st, 2025. I will say for this group, there's also a series of open meeting law legislation that's currently up at the State House that may or may not make further adjustments. And essentially it does allow adequate alternative means of public access, and public body members can participate remotely if they need to. The changes don't require that meetings be held remotely, but they do allow it. So sometimes, things come up if meetings are held virtually. We're dealing with some tech matters tonight, and I appreciate everyone's patience and cooperation in working through that. It looks like we're good now, so thank you all. When meetings are conducted by public bodies virtually, the meeting notice must provide instructions. One thing, you want to make sure that the meeting link is updated if you're using a different link to make sure it doesn't go to an old agenda, something that can happen from time to time. If some public body members are participating in person, it's an in-person meeting, and some others are remote, the chair has to identify the members who are remote, which should be included in the meeting minutes. All votes that are taken in a virtual meeting or a hybrid meeting, if some members are remote, should be by roll call vote, even if it's unanimous. So we'll go through each member and say how he or she is going to vote. And all other provisions of the open meeting law do apply. So just something to keep in mind. Technical difficulties, it happens from time to time. If a technical problem prevents a remote meeting from being accessible in real time, the live stream goes down, there's a significant delay, it's glitchy, etc., the meeting should really be paused or rescheduled depending on the severity of the issue. So obviously, if there's a power outage and there's no ability for members of the public to access the meeting in real time, you're going to want to reschedule the meeting most likely, or pause it until the issues are resolved. We know from the Attorney General's office that continuing a meeting, even if there are technical difficulties, and then posting a recording, even immediately afterwards, doesn't cure an open meeting law violation. The public has to be able to access the meeting as it happens. If a technical difficulties result in a remote participant participating remotely, disconnected from the meeting, then it should be noted in the meeting minutes when that person was disconnected and regained access. Okay, any questions on any of that from anyone here or remote? Okay. Executive sessions, we're very technical. We're gonna cover the basics of that this evening. I've also provided some great resources at the end of this presentation that you will all have that goes over executive session in detail through the Attorney General's open meeting law division. And also materials that Town Council's office has prepared on this issue. There are also checklists that are available. So I really want to go over the overviews tonight. As I mentioned before, you're going to want to convene an open session before the enter into executive session and state the purpose of an executive session to the extent you can. There may be circumstances, in particular for purpose one, where you can't, provide the identity of an individual, but really you want to be careful that you're including enough specificity in compliance with the law. You're going to take and record roll call votes to go into executive session and announce to members of the public if the open session is going to reconvene afterwards. And that's really important so people know, oh, there's going to be public business conducted at the end, or no, it's going to end in executive session, so I'm not going to stay for the end of that meeting. Maintain records, exhibits, and documents used in reasonable proximity of the minutes. So there's two different types of minutes. Open session minutes are generally publicly available. They're usually put on the website once they're approved. And executive session minutes are confidential. They're approved in executive session and they remain confidential until the executive session purpose has expired. So I'll give a classic example. you have litigation, your public body meets, because of that litigation, the litigation resolves, those meeting minutes may be allowed to be provided because the purpose has expired, but there may be, for instance, privileged information or other confidential information, so those will have to be reviewed. So care should be taken to make sure those executive session minutes maintain their confidentiality in compliance with both the open meeting law and the public records law. When you are in executive session, if you do have a proper purpose to go into executive session, you really want to stick to what that purpose is and discuss those matters cited. You want to make sure that the conversation is really confined to why you can enter into this confidential session. And then take all votes by roll call vote as well. I've included here some practical considerations as you start navigating your new role with the town as a public body member. And again, wanted to just provide all of these overviews for you to the extent you need them. Meeting minutes. Meeting minutes are a large part of what the open meeting law requires for public body members. We know that meeting minutes must be kept for all meetings. They have to have the date, time, place of the meeting, and the members present or absent. We talked a lot before about how meeting minutes don't need to be a verbatim transcript, but they should be a detailed summary of the discussion. What does that mean? The decisions made, the actions taken, and the votes recorded. And you also want to include a list of documents or records that were used by the public body. That may be, for example, an application, it may be a plan, it may be a map, it may be a consultant's report, an engineering report, it may be any other background material that you received from town personnel or a town official regarding the matter before you. But you want to make it clear that, again, a member of the public sitting at home will say that, the ZBA reviewed these 4 documents as part of this application. So it's a comprehensive record of what had transpired. Minutes, approval of meeting minutes is really important. Generally, there are some exceptions, but generally they should be approved within the next 3 meetings or within 30 days, whichever is later. And they are public records. We're going to talk about the public records law as of the moment of their creation, regardless of whether they've been approved. So if someone is taking meeting minutes, someone can request those in draft form, something to be cognizant of. Meeting minutes, if there was a request for meeting minutes for an open session to the chair of a public body, they need to be made available within 10 days. And steps should really be taken to the extent you can. Obviously, town boards, commissions, committees get very busy and try to stay as up to date as you can with respect to your drafting and approval. Executive session minutes, we talked about those a little bit. Those are the confidential meeting minutes. I know that those can be withheld or kept confidential until the purpose of the executive session has been met, unless they're otherwise protected under the public records law. There is an obligation to review those executive session minutes periodically and to determine whether or not that executive session has expired. And you can approve the meeting minutes in executive session, either under the purpose for which it was originally held. So if you're meeting on a particular litigation matter, that would be purpose 3. Or if there's more than one purpose, you can reference exemption 7 or purpose 7, referencing the open meeting law that allows you to do that. You do have to provide a response to a request for executive session meeting minutes within 10 calendar days generally, and you cannot assess a fee for the time spent reviewing those. I'm going to spend a little bit of time before we move into the public records component of the training on enforcement, and this isn't certainly means to scare anyone or to detract from any of the public work that you all are doing for the town of Dedham. It's certainly just to make you all aware of if you did see a complaint, this is the process, and this is essentially what the Attorney General's office has set forth regarding a complainant filing an open meeting law complaint. Generally, a complaint of an allegation of violation of the open meeting law has to be filed with the public body within 30 days of the alleged violation. And then from there, the public body forwards a complaint, it to the Attorney General's office with a response to it. Yes, we think this happened, or we think it didn't. So it's within 14 business days, a copy of the complaint and any action taken by the public body. There's generally a meeting to review those allegations. After that, if the complainant is satisfied, they're happy with the response by the public body, nothing further would generally transpire. If they're not, they can also seek further review with the Division of Open Government, the Attorney General's office. We know that a public body has to consider a complaint at a properly posted meeting. So it should appear on the meeting notice and you would acknowledge receipt of the complaint. There are times where it would be appropriate to meet to discuss an open meeting law complaint in executive session. So certainly that's something you'd want to review with town council. And there's the ability to cure a violation. If there was an action taken or a mishap or something transpired, it may be that a cure is possible, and that would be a public deliberation about something that transpired outside of the other requirements of the open meeting law. Open meeting law certification requirements, just wanted to flag this for everyone here tonight and everyone online. Open meeting law certification is online. The form is online. I've provided the resource at the end of the presentation. It is required within 2 weeks of a member's election or appointment or taking the oath of office, whichever is later. It has to be retained by the town, and each member has to sign a new open meeting law certification upon re-election or reappointment, but is not required if you're joining a subcommittee. So here's the specific information on open meeting law certification for anyone that may need it, and the link is at the end of this presentation as well. So we're going to move into some notable court decisions. I don't know if anyone has questions. Are you good? Any questions?
On this last part that you just went over, the open meeting law certification.
Sure.
Now, people that are viewing this now, does that qualify them as being certified?
No, it's actually, that's a great question. Thank you so much for asking. So this training is great. It's required as part of your service to the town. The open meeting law certification requirement is separate and apart from what we're doing here tonight. So there's an open meeting law guide that the Attorney General's office has put out. And on the website, which is at the end of this presentation, there's a link that says public body member certification. You click on the link, very similar to the conflict of interest training. There's a specific form that gets filled out, and then an acknowledgement that you've read the materials that are set forth
Okay,
on the website. Good question, thank you. So I've provided here some recent notable court decisions in the open meeting law public comment context. And we're going to talk about, constitutional considerations and public comment a little bit, but just wanted to make sure everyone was aware of this. So the first case I really want to spend the most time talking about, and that is the Barron versus Kalenda case. Many of you may have heard of this case. There's a detailed summary of this case and its implications on our website, on town council's website, and the link is at the end. But basically, the case involved the constitutionality of a public comment period and a public comment policy. And what we know, while the case didn't specifically talk about the open meeting law, the court essentially determined that the board invited public comment by including a public comment on its meeting agenda, and we'll talk about the town's public comment policy as well. And that once public comment was included, the court concluded essentially that free speech, that constitutional considerations apply to the efforts to regulate public comments. So while we know that state law, the town has a public comment policy, I'm certainly aware of. While state law doesn't require municipalities to provide public comment generally, some charters and special acts, as many of you know, does require public comment periods. And so you have a public comment policy, it's on the town's website, certainly worth reviewing relative to the time place and manner restrictions of how the town, the select board have determined public comment should be structured. Something worth double checking, obviously, as part of your role in town government. The other cases are certainly for reference. The Corey Spalding case was there's a case that came out before Barron from 2018. Talked about public comment during public meetings as well. So just something to be aware of, and certainly reviewing your public comment policy. The general rule is that any rules about public participation have to really relate to the process for such participation and can't relate to the speech, what an individual says. That's protected by constitutional principles, and that any restrictions on speech, including as to time, must be content neutral. So what that means is doesn't matter what an individual says or doesn't say, and narrowly tailored to the public body's interest. I have provided a link here for everyone's reference to the public comment policy for the town. Definitely recommend reviewing that in your capacity as a public body member. And here are some items to consider consistent with the town's public comment policy. You know, one, you certainly want to avoid debate, avoid responding to a comment before the board or the commission or the committee may have an opportunity to discuss it. And you may not want to engage because of open meeting law considerations if it hasn't been posted on the agenda, and really consider putting it on if it's a matter that needs to be discussed at a future time. Okay, any questions? I'm going to go to our online participants. If anyone has any questions, feel free to, oh, Ellie has a question.
It has to do with the open meeting law. Who provides the certification again? Can you just clarify that? It says
Sure.
within 2 weeks of your appointment, because I haven't been certified.
Sure, so thank you, good question, Ellie, I appreciate it. So there is information at the end of the presentation. You'll see it when we get to the end of it, that has a link to the Attorney General's Division of Open Government. And if you go to the Division of Open Government's webpage, there's a link that says Public Body Member Certification, and you just click on the link and it has the directions right there.
So it's my responsibility to go to the Attorney General website to do this?
It's a one-page form that just needs to be completed.
Yes, but in other words, I need to do this. It's not the state that, I mean, it's not the town that comes to me to do this.
Yes, it would be something that you would complete as a public body member.
Okay, and it's for appointed and elected, right?
That's correct. Thank you, good question. So we're going to move on. I don't see any other questions. We're going to move on to the public records law. Many of you may be familiar with the public records law and what it requires. So where the open meeting law really deals with how public bodies conduct their business, the public records law essentially relates to all of the documents that town officials or employees may have in their capacity for doing work on behalf of the town. So we're going to cover what is a public record, when do records have to be disclosed, and when can the town just destroy records, because there are specific retention periods. And I know some of this may not apply to all of you that are in the training tonight, but it's certainly a good reminder of some of these government transparency issues. And particularly the use of personal email or cell phones or notepads in serving in your role as a town elected or appointed member. And again, I start with the definition because it's very broad. We know that a public record is a book, a paper, a map, a photograph, tapes, emails. It essentially doesn't matter what the physical form of this is. It doesn't need to be a physical piece of paper in front of you. It may be a text message. It may be an email. It may be a recording. It may be a video recording or an audio recording. So it is very, very broadly defined. Public records requests, the town gets many public records requests throughout the course of the year. A request can be made in person or in writing. email or fax. We don't see fax as much, but sometimes we do. And the town's records access officer has to respond within 10 business days. So it's not calendar days, as with the minutes request to a chair of a public body under the open meeting law. It's calendar days. If the response doesn't provide all of the requested records, then a detailed response is required. And this is really usually something that, as a public body member, you may be asked to provide documents. So I always like to include, even if you're not drafting the response. So I always like to provide this as part of the overview, so you understand the legal requirements if there is a public records request that you might get involved in. There may be some certain exemptions, and we'll cover basic exemptions under the public records law when records may or may not need to be provided or can be redacted. And there may be an explanation that's provided to the requester as well. So here's the timeline of 10 business days to respond. So you're gonna, if there was a request that you may or may not have records about and someone inquires, you're gonna really wanna work to make sure you do a diligent search of your records to say, yes, I have these emails, or I have these notes, or I have these records, or no, I don't. We're going to go over essentially the elements of the response, and those are all available for everyone here tonight as well, in case you ever have to deal with that. But essentially it's confirming the receipt and date of the request, identifying the categories of records. So if you're provided with a public records request and someone says, you know, someone says essentially like, do you have these records? Yes, I have records for one. No, I don't have for two. And you'll have to do that work to identify any records that you may have. There are some circumstances where the town decides it's a large request, or it's going to take a lot of time, or it's a very broad in terms of time frame, where essentially there may be an extension requested, or there's a good faith estimate that's done because of the volume of work required. So I've included that all here if anyone has any specific questions. But essentially really just a flag for everyone that their records in your work with the town are subject to the public records law if you're writing them on town business, regardless of you using a personal device or a town device. This is the overview of fees that can be charged. So if you are involved in a request and it is voluminous, it's something to be aware of, that the town does have the ability to charge fees. You're not eligible for waiver of the town is eligible because of its population it has to charge can't charge for the first 2 hours, so something to be aware of. I wanted to go over some commonly used public records exemptions. Exemption A, so if there is a public records request, there may be some documents that are particularly sensitive. And so because those documents are sensitive, a specific exemption may apply. Some common examples of exemption A, which are basically records that are confidential under state law, maybe CORI, domestic violence reports. These are more in the police context, student records, NCAD documents, or abatement applications. So the state has recognized specific confidentiality related to these particular types of documents. And as a result, if there's a records request dealing with them, exemption A may apply. Exemption C, we call a privacy exemption. It's generally limited to medical information, personnel information, or details of a highly personal nature. And we'll talk a little bit about being cognizant if you write an email or you write a text message to not include sensitive information, because if your records are requested as part of a public records request, we obviously want to be really careful that we're not providing someone's confidential information. Deliberative process is another one that comes up from time to time if there's an ongoing policy or legal matter that's being reviewed. Exemption E, I mentioned earlier. Exemption E is essentially your personal notes. So if you are taking your own personal notes, and this isn't meeting minutes, this is just your notes to yourself, and they're not part of the official file, and they haven't been shared with another member of the board or the commission or the committee, or they haven't made part of the town file, there may be an exemption E reason to say, nope, these are my personal notes, I haven't shared them with anyone else, and that exemption applies. Exemption F is really more in the police context that relates to ongoing investigations. Exemption N, the legislature has said that records related to infrastructure, blueprints, security documents, any record that may impact or jeopardize public safety may be withheld under exemption N. After that analysis is done, and that would also apply, it's been updated to include cybersecurity. Exemption O is the personal email address, home telephone number of a public employee. If we have a list of all the town employees, we would not provide their personal information if it was a public records request for that. There's an appeal process similar to, oh, we have a question here. Thanks, Ellie. Let me just unmute you. Hold on 1 second.
I had to unmute, my apologies. I am a person who takes a lot of notes, but you're saying that if those notes, if I'm not the official note taker, those are considered my personal notes and I don't have to reveal them to anybody.
That's correct. Good question, Ellie. Thank you. So if they're your personal notes, you take them as part of your own, you know, your personal deliberation, shall we say, and they're not shared with any other member of your public body or any other town staff member or any other personnel. You just keep them to yourself for your own mental impression, so to speak. Then we would make the argument that those would be exempt under exemption E if there was a public records request for them. It does become very fact specific, you know, did Ellie show Janelle, did Ellie show Sam? So I just want to flag that, but if you're taking notes for your own personal use for your impressions, I think exemption E would likely apply. Good
Okay,
question.
thank you.
Thank you. Any other questions from any of the online participants? Okay, thank you. So there's an appeal process if a particular requester is unsatisfied with the town's response to the public records law, and that may be, they think an estimate is too high. They think that they're entitled to records that the town has said are exempt under some of the exemptions we just talked about, or they think that additional records exist that haven't been provided. They would appeal. Generally speaking, most of the appeals go to the state's supervisor of public records. There's a public records division. It is a state agency that oversees appeals of public records challenges. If an individual is dissatisfied, they can also appeal to Superior Court. The Attorney General's office may enforce orders of the supervisor or bring her own suit if necessary. In addition, a requester can directly appeal to Superior Court. This isn't something, you know, most likely that comes up quite often, but there is, if a lawsuit is filed, there is a presumption for the award of attorney's fees against a public entity, a municipality, if the plaintiff is successful, even in part, once a suit is filed, if the town provides the requested records. This was a change to the law back in 2016, and so we want to certainly be cognizant of it. If you're asked to provide your records, best to just make sure you do a diligent search and provide anything you can to town officials that are handling the public records request. So there is now, I started doing this work a long time ago, and now the movement has been towards moving it in electronic record preference. So what does that mean? The town's website is great. It has a lot of information on there. Over time, more and more information is put on municipal websites. Generally, the Public Records Division of Public Records Law requires to post as many records as you possibly can. You know, annual reports, notices of hearings, and these may vary from community to community, but here's just a list of some examples that generally are included online. Best practices for public body members for email and electronic records. If you can use a town email account, if you have access to one for town business or a separate account, If you don't have a town account, it's always the best practice to do that, to keep it separate. I've had multiple experiences over the years where there's either a public records request or a subpoena in a case, and someone has to check their work email or go to their work IT to say, I may have emails about this topic, I need you to pull it off my work server. Or they have to go through their personal email account to figure out which is town business and which isn't. So to the extent you can have a separate account, it's really much easier to deal with public records requirements, both retention and searching if necessary. If you do keep records or make records or receive records in your role as a public body member, you're gonna wanna deliver those to town hall or off the town servers to anything that's off the town server to town hall. And that is really under the Massachusetts municipal records retention schedule, because the town is required to keep certain records for certain periods of time. We talked about this in the open meeting law context, but I wanted to reiterate it in the public records context as well. Ensure that when you hit send on an email, you're comfortable with the email being forwarded, printed, posted, and tweeted. Use a formal tone when conducting town business and writing. And we talked about this a couple of minutes ago, but you really want to avoid asking for or providing either your own personal information or someone else's personal information in your town emails, including medical information, unpublished telephone numbers, social security numbers, financial account numbers, and the like. And that obviously has cybersecurity considerations, but also to the extent there's a records request for that, all of those documents would need to be reviewed. Consider whether a formal record is required. You know, as years ago, when we were dealing with another issue, as one town manager put it, the telephone still works. So just any record created or received in your capacity as a public body member is subject to the public records law. So just wanted to really emphasize that. Any questions before we move on? Let's check. Okay, looks like we're good. So I'm sure many of you have done the conflict of interest law training. Has been updated. There's a new online training protocol. I've included it at the end of these materials. And I know that it's very detailed. It's a really comprehensive training protocol that the State Ethics Commission puts out. So we're just gonna really go through this fairly quickly, but I wanted to make sure we covered some of these topics. And then you will want to make sure you comply with the conflict of interest training requirements already if you haven't done so. So conflict of interest for municipal employees is General Laws Chapter 268A. That's the conflict of interest law. And here I've included the different sections that would apply to quote unquote municipal employees. And essentially, you know, they're fairly obvious from a bias or conflict perspective, but just want to make sure everyone understands what the requirements are under section 17, section 19, which pertains to financial interest. That's usually, you know, something that comes up. Questions come up from time to time on that, obviously very fact specific. Municipal employee may not participate in a manner in which a business in which they are an owner, director, employee, or an immediate family member has a financial interest. Multiple positions or contracts, and then the code of conduct as well, which is essentially that a municipal employee cannot participate in a matter which it appears it might act for reasons other than the town's best interests. I've included here the key definitions. I think it's always a good idea to include the one that comes up quite often is what is immediate family. Which is really the employee's spouse, and employees and spouse's parents, children, brothers, and sisters. And the disclosure forms under the conflict of interest law, if anyone ever needs them, are available on the state ethics website. Code of conduct general standards, and this is covered by section 23 of the conflict of interest law, establishes a so-called code of conduct that's applicable to all municipal employees, regardless of whether they are compensated. This is the $50 rule that I've included in the first bullet here. And as well as under 23B3, that a municipal employee may not act in a manner which would cause a reasonable person having knowledge of the circumstances to conclude that an individual is acting with bias, favoritism, or otherwise for personal employees. There is a disclosure form that can be filed. So just wanted to make sure everyone was aware of those general standards for code of conduct. Restrictions on gifts. Under 268 section 3, you cannot accept a gift of substantial value, which has been defined as $50 or more, if given for because an official act performed or to be performed under your official responsibility. There are regulations that specifically address gifts, and there are some gifts that are exempt under the conflict of interest law. Some other gifts require additional written disclosures and others are just straight prohibited. Exempted gifts entirely unrelated to your office or any official action that you may take, birthday present, discount plan, raffle product, etc. I've included the relevant information about disclosure of gifts and when that is allowed. So you want to obviously do a disclosure to avoid the appearance of impropriety regarding code of conduct issues. Written disclosures required if it is related to officer action and less than $50. So just want to make sure everyone had that information. There are specific exemptions, travel expenses, job-related purposes, conferences, if a legitimate public purpose, and quote unquote incidental hospitality, refreshments, etc. Section 17 is receiving money from or acting as an agent for a private party. So that is ethics. The Ethics Commission has said that a municipal employee cannot receive compensation from anyone other than the town or act as an agent or attorney from anyone other than the town with regard to any particular matter which the town is a party or has a direct and substantial interest. And the purpose here is really just to avoid the appearance of actual or divided alleged allegiance. So just wanted to make sure everyone was aware of that specific requirement under section 17. Agent is defined as follows. If you think you might be dealing with this particular issue, obviously it's a personal matter, so you'll want to double check relative to the specific definitions at play. I get asked this question quite frequently. The exemption to acting as an agent is you can always advocate for yourself in your individual capacity. Doing so is not acting as an agent. So just wanted to make sure everyone had that information as well. Financial interests, immediate family member would define that. A municipal employee cannot participate in their official capacity in any particular matter in which their immediate family member or their private business or employer has a financial interest regardless of the size of the financial interest. And so that's something to certainly be aware of. There is an exemption available for appointed officials only, and you can disclose the apparent conflict prior to participating and seek written approval from your appointing authority, but that approval is not automatic. And the appointing authority must conclude that the conflict will not interfere with service being provided to the town. Financial interest is any amount, large or small, positive or negative. And we all know, many of us know about the 300-foot rule as well with respect to abutters. We have a question. Contracts in multiple positions. Municipal employee cannot have a financial interest in a contract with the town. That's under 268A section 20. And a contract includes a second office if paid, unless an employee qualifies for one of the exemptions. These are incredibly fact specific. Oh, Ellie does have a question. These are incredibly fact specific, so definitely worth reviewing if you think this may implicate anything that you are dealing with based on your personal situation. Did you have a question, Ellie?
Yes, I just want to confirm that appointed I apologize because this definition was given a while ago, but appointed members are considered special municipal employees? Or not?
Were we going back? Let me just pull back that slide. I'm cognizant of the screen sharing, so I just want to make sure I understand your question.
Well, I'm just trying to clarify. I'm an appointed member. I'm not an employee of the town, but I'm an
Mhm.
appointed member of a board. And so my status is special municipal employee? I'm not quite clear what my status is in terms of conflict of interest.
Sure, so you are a municipal employee, so we can go back to the slide. Let me see if I can go back. Just
Am
so
I
we
a
can walk.
special municipal employee? Because I'm not employed by the town. I'm a volunteer,
But
appointed by the town manager.
yeah, you're appointed though. I'm gonna go back to that slide and we'll walk through it together, okay? Okay, so the definition of municipal employee is a person performing services for or holding an office, position, employment, or membership in a municipal agency, whether by election, appointment, contract of hire, or engagement, whether serving with or without compensation.
Okay, so I am considered a municipal employee, not a special municipal employee.
Correct, because that's a position that's been designated by the board, is unpaid or part-time, and is treated less stringently because of its sort of narrow role, if that makes sense.
Okay.
But you said you're appointed,
I'm an
correct?
appointed by the town manager to a board.
Yep. So you are currently appointed, serving without compensation under
Correct.
the definition of municipal employee.
Okay, thank you.
Thank you. I think we're up to here. We went, oh, here. Yeah. Okay. Financial interest, contracts, and I'm happy to take other questions at the end as well for anyone. Financial interest, contracts, and multiple positions. So under 268, section 20B, for a regular municipal employee to hold another paid position with the town, an exemption is available, and these are the requirements. If the contract's with a different department, if it's made after a public notice, and usually that's in the local newspaper, if an employee files a written disclosure with the town clerk, and if the contract for personal services is outside of the normal hours of the primary position. Again, very fact specific in terms of what the specific scope is, but just wanted to make sure everyone was aware of that to the extent it impacted anyone's role that's here tonight. Here are some additional resources, and I've included these as well with hyperlinks. So one, the Attorney General's open meeting law resources and certification information. This is through the Division of Open Government that I mentioned before. Really comprehensive resources relative to the open meeting law. There are also additional training protocols there in case there are any other questions. But certainly it's a good idea to review that and complete your certification if it hasn't been done. To the Public Records Division, and that's through the Secretary of State's office. That has a updated public records guide that was published in 2022 that covers what the public records law is and any exemptions. And the conflict of interest training materials, it's a very comprehensive training protocol. Many of you have probably already done it, both town officials and employees. That's the link there. And then certainly our resources as well. There's public records law resources, the full analysis of that therein, public comment policy case I talked about, as well as public records law and other government transparency issues as well. happy to answer any other questions that anyone has, and really appreciate everyone's time out of their schedule this evening. And if there's any follow-up questions, feel free to reach out to me directly. My information's on the website. You can always call or email, or certainly reach out to the town manager's office if there's any specific questions, and I appreciate everyone's time this evening. Thank you.
Thank you.
We have a question. Yep.
Thank you. Thank you.
Oh, thank you very much. Thanks, Annette. Thank you all.